Justice does not come wearing a halo. Sometimes it walks into my courtroom in Balenciaga heels, looks me dead in the eye, and asks whether the law can still hear a poor woman over the sound of money. Come sit with me for this one, because I have carried it longer than any case file should sit inside a human chest. Stay close, and I will tell you how a crowded courtroom in Belhaven learned what power sounds like when it finally starts to crack. Some stories belong in the record. This one belongs to anyone who still wants to believe the truth can outlast a last name. It was Tuesday, 17th June 2025, and the air over Belhaven, Ohio, still smelled like wet brick from the storm that had rolled through before dawn. I unlocked my chambers at Belhaven Municipal Court at 6:12 a.m., same as I always did, with black coffee in one hand and my leather case in the other. The courthouse sits at 214 Water Street, old limestone, old pipes, old ghosts, and I have loved that building for 28 years. My clerk, Eileen Foster, was already at her desk with her reading glasses low on her nose and a stack of files lined up like soldiers. She looked up and said, "Morning, Judge. Full docket. One of them may need your whole spine." That was Eileen. She did not waste words, and when she said a thing twice in 1 week, I paid attention. Sergeant Roy Haskins, my bailiff, was by the rail checking the latch on the side gate. He had been in that courtroom so long he could tell a liar by the way they sat down. He gave me one look and said, "Press bench in the gallery today, also a district staffer, case 25 CRB 1847. Then he tapped the file with one thick finger and added, "Congressman Whitmore's daughter." I remember laying my coffee beside the lamp and resting my hand on that folder before I opened it. My father used to tell me that the small cases are only small to people who do not have to live with the damage. He was a lawyer before me, and long before I ever took evidence in a courtroom, he taught me that rules without heart become weapons. He also taught me something I have never forgotten. The courtroom is the last place on earth where every single person must be treated as equal, or it stops being a courtroom at all. When the clerk called the case at 9:03 a.m., I already knew the weather, the names, the charge codes, the police supplements, and the repair estimate. What I did not know yet was that before noon that same day, a congressman's daughter would pull out her phone at counsel table, call 911 on me in open court, and then learn exactly what emergency lines are for. The defendant came in first, and the room felt it before the door even closed behind her. Camille Elaine Whitmore, 24 years old, moved like a woman who had never once waited where other people waited. She wore a cream Balenciaga blazer over white silk, a narrow Hermes belt, black Tom Ford heels, and a Rolex Datejust that flashed every time she brushed her hair back from her face. Her phone sat inside a Louis Vuitton case with gold corners, and she placed it on the table the way some people set down a weapon. She did not look at me first. She looked at the gallery, then at the camera from one local station, then at the prosecutor as if trying to decide whether he was worth a full expression. Her mouth made one thin line when she saw the victim already seated. Not fear, not shame, just annoyance, as if a bill she thought had been settled had somehow found its way back to her. Her attorney, Martin Keene, was a skilled defense lawyer with a calm voice and a tired briefcase. I had known him a long time. He gave me a small, respectful nod that said he knew this would not be easy. Camille sat down beside him and leaned back before I'd even taken the bench. That always tells me something. People who understand the court usually sit forward. If you have ever met someone who keeps a whole family alive with no applause, then you know why I could not stop looking at Angela Ruiz that morning. Do you know a person like that? The one who never raises their voice because they are too busy carrying everybody else? I want you to hold that person in your mind while I tell you what happened next. Angela Sophia Ruiz was 43 years old, and she looked like she had been awake longer than the clock could fairly measure. She wore navy scrub pants under a faded gray cardigan because she had come straight from the hospital after changing shoes in the staff restroom. Her work shoes were plain black nursing clogs, the left toe scuffed white. Her dark hair was pulled back tight with no time wasted on vanity, and she held a manila folder against her chest with both hands as if keeping the paper steady also kept her steady. She had worked 19 years on the pediatric floor at St. Agnes Medical Center, Unit 5B in Belhaven. 19 years of fevers, broken bones, midnight breathing treatments, small hands wrapped around her thumb, and parents who wanted one more answer she could not always give. Her husband, Daniel Ruiz, had died in a scaffolding fall in October of 2019. Since then, she had raised her 12-year-old son, Mateo, alone, while also caring for her mother, Teresa Ruiz, age 71, who needed dialysis every Monday, Wednesday, and Friday. Money in that family did not stretch. It scraped. Angela drove a 2011 Honda Civic with 182,406 miles on it. She was paying $148 a month on the funeral loan from her husband's burial and fighting with insurance every other refill because Mateo's seizure medicine was never covered the way it should have been. She did not say any of that to win sympathy. Most of it came from sworn testimony, payroll records, pharmacy receipts, and the kind of tired truth that leaves fingerprints on every page. When I asked her to stand for identification, she rose slowly, shoulders straight, chin level, eyes on me. She did not glare at Camille. She did not perform pain for the room. She simply answered each question in a low, careful voice, like every word had weight, and she could not afford to waste even one. That kind of restraint carries more force in a courtroom than tears ever will. The incident itself had happened on Friday, 14th of March, 2025 at 10:47 p.m. outside Harper Family Pharmacy at 212 East Mercer Street. Angela had finished a double shift at St. Agnes at 9:58 p.m. She drove across town in light rain because Mateo's levetiracetam refill had to be picked up before the pharmacy closed at 11 p.m. Her mother was home with him, and the boy needed that dose by 11:30 if they were going to avoid a rough night. The Bellhaven spring that week had been cold and damp, and the parking lot cameras showed the shine of rainwater under the street lamps. Angela pulled in at 10:42 p.m. She went inside, paid the copay, and returned to her car with a white pharmacy bag and a paper cup of coffee she had not even started. When she came back out, the curbside pickup lane was blocked by a black Porsche Cayenne Turbo. Engine running, hazards off, music loud enough that the bass showed in the security stills. That Porsche belonged to Camille Whitmore. The registration was in her own name, though the insurance policy listed a Virginia address used by her father's congressional office. When Angela approached, Camille was standing half outside the driver's door filming herself on her phone. 1 foot on the wet pavement, 1 foot still inside the car, head turned toward the screen, perfect lipstick, perfect lighting from the pharmacy sign, perfect contempt. Angela asked if she would please move up a few feet so she could get out of the lane, not shouted, not snapped, asked. Nia Holloway, the pharmacy tech on closing shift, would later testify that she heard Angela say, "Ma'am, I just need to get home to my son, please." That one word, please, sat in the room a long time when Nia said it. According to the first police report, Camille answered, "Then go around." According to 2 later witnesses, she also said, "You people always think your rush matters more." Angela got into her Civic anyway. She backed carefully, trying to turn around the Porsche on the wet lot. At 10:47 p.m. and 58 seconds, the Porsche lurched forward. Not much, just enough. Front right bumper into the driver's side door and quarter panel of the Civic, enough to crease metal and jam the door. A lot of people think the sound of a small collision is loud. It is not always loud. Sometimes it is a hard, ugly crunch that feels private, the kind you hear more in your teeth than your ears. Samuel Ortiz, the lot monitor from the medical building next door, described it exactly that way. He said he heard the metal fold and then heard a woman laugh. Stay with me here and test your own instincts against mine. When money walks into a room first, a lot of people decide the ending before the evidence even starts. I am asking you not to do that. I am asking you to sit through every piece of this with me and see whether the truth can still catch a person who thinks she is too polished to leave fingerprints. Camille did not check on Angela first. She did not ask if anyone was hurt. She did not step out into the rain to look at the damage like ordinary people do after an accident. She lifted her phone, hit a screen, and at 10:48 p.m. placed a 911 call from beside her Porsche while Angela was still trying to force her own door open from the inside. Officers Daniel Pike, badge 417, and Meredith Sloan, badge 233, were dispatched at 10:49 p.m. and arrived at 10:56 p.m. Officer Pike testified that when he got there, he saw Angela standing beside the Civic in wet navy scrubs, one hand still holding the pharmacy bag, the other pressed against the damaged door. Camille was leaning against the Porsche under the awning, dry as a showroom floor, speaking quickly and pointing with two fingers as if ordering food. Officer Pike's first report called it a vehicle contact dispute with conflicting statements. He noted the Civic's damage and minor transfer on the Porsche bumper. He also wrote that the complainant, Camille Whitmore, alleged Angela advanced toward her in an aggressive manner. That word, aggressive, would matter later. Too much, as it turned out. Because Camille made the 911 call first, the whole scene tilted around her version at the beginning. That happens more than people know. The first voice can set the weather for everybody who speaks after. Angela was questioned. Her hospital badge was copied, the pharmacy doors locked at 11 p.m. while she was still outside with the officers, and the refill she had paid for was taken back inside. When the prosecutor laid out the timeline, I could feel something in the room begin to tighten. Angela was released from the scene at 11:19 p.m. She still had a damaged car door. She still had a 12-year-old son at home waiting for medicine. She still had a long drive through rain. And sitting at counsel table 10 feet away, Camille Whitmore crossed one elegant leg over the other and looked bored. The first time I turned to her that morning and asked if she understood the charges of criminal damaging, false report, misuse of emergency services, and reckless operation, she gave a soft laugh before she answered. "I understand the words," she said. "I just don't agree that this belongs in a real court." There was a murmur from the gallery. I let it settle on its own before I spoke. I told her in the same tone I use with everyone that Belhaven Municipal Court was real enough for every person standing before it, and that agreement was not required. She pressed her lips together and looked down at her nails. Martin Keene put one hand near her sleeve without quite touching it. That small gesture told me he was already trying to hold a storm inside a teacup. The prosecution then called Angela to explain what happened after the officers left the lot, and I watched her tighten her grip on that folder before she answered. She said she got home at 11:41 p.m. on Friday, 14th of March, 2025. Mateo was on the couch under a green fleece blanket, still dressed in his school clothes, trying hard not to worry his grandmother. Teresa Ruiz had set out a spoon, applesauce, and the small plastic medicine cup the way Angela always did on seizure nights. Angela told me she had to look at her son and say, "The pharmacy bag has the receipt, baby, but not the bottle." She did not cry when she said it. That was the hard part. She just stood there in that plain cardigan and spoke in the same steady tone she would use to tell a parent a fever was rising and they needed to stay calm. She said Mateo had his first warning signs at 12:19 a.m. He went pale. He rubbed his left hand against his knee. He said the kitchen light looked wrong. At 12:27 a.m., he had a breakthrough seizure in the hallway outside the bathroom. Teresa called 911 at 12:31 a.m. Belhaven EMS run sheet 25031577 showed medics arrived at 12:38 a.m. and transported Mateo to St. Agnes at 12:47 a.m. Angela met them there in her damaged Civic because she still did not have time to think about tow trucks or police supplements or what a woman in a Porsche had just done to her life. The prosecutor, Neil Benton, asked what the seizure cost her family in plain terms. Angela looked down for the first time. She said, "It cost my son a safe night. It cost him sleep. It cost him the inside of his cheek because he bit through it. It cost my mother a week of peace. It cost me 2 shifts because I stayed with him until Saturday afternoon." Then she added, almost like she was embarrassed to say money out loud, "The ambulance bill was $936.40. I have heard victim impact statements for almost 3 decades. Some are loud, some are soft. The ones that stay with me are usually soft." Angela said Mateo kept asking in the emergency room if the police were mad at her. He had seen the dent in the car. He had heard enough to understand there had been trouble. He asked his mother if she had gotten in a fight for the medicine. When she repeated those words in my courtroom, the room did not move. Neil Benton then handed up the repair estimate from Mercer Auto Body dated 18th of March, 2025. Driver side door replacement, quarter panel work, paint, labor, alignment check. Total cost $4,286.73. There was also a rental car invoice for $418.97 because the Civic's driver door would not open from the outside and had to be climbed over from the passenger side for 11 days. Angela testified she used that rental to get her mother to dialysis and her son back to school. Martin Keene cross-examined carefully. He was not cruel. He knew what the juryless room already knew, which was that the facts were beginning to carry their own weight. He asked whether Angela had raised her voice in the lot. She said, "I was tired and wet and worried, but I did not raise my voice." He asked whether she had stepped toward Camille's car. She said, "I stepped toward the open lane because I was trying to leave." He asked whether she might have mistaken a slow roll on wet pavement for intent. Angela looked at him and said, "Counselor, I know the difference between a car drifting and a person deciding." That answer made even Sergeant Haskins shift his stance by the rail. In a courtroom, truth sometimes enters not like thunder, but like a key turning in an old lock. One sound, then everyone knows the door is open. If you are still here with me, then you are part of the small, stubborn group of people who believe ordinary lives matter, even when they are not famous, rich, or loud. I want you to stay in that place for a moment. Stories like this only mean something because people like you refuse to look away from quiet harm. Neil Benton called Nia Simone Holloway next. Nia was 29, a certified pharmacy technician with Harper Family Pharmacy, and she arrived in her Greenworks smock because she had come straight from her morning shift. She raised her right hand, took the oath, and sat down with both feet tucked squarely under the chair like she meant to stay steady. Nia testified that she saw Camille's Porsche blocking the lane when she stepped outside at 10:45 p.m. to take in the sidewalk sign before closing. She said she recognized Camille because of her online videos and because Camille had been in the store 2 minutes earlier buying bottled water and a collagen drink. When Neil asked if she saw Angela approach, Nia said yes. Ms. Ruiz walked up slow. She had a white pharmacy bag and coffee. She looked tired. She said, "Ma'am, I just need to get home to my son. Please move up a little." Then Neil asked the question that mattered. How did Ms. Whitmore respond? Nia did not rush. She said, she smiled at her phone first. Then she said, "Then go around, nurse." The word nurse landed hard because Nia made clear Camille knew exactly who she was speaking to. Angela's hospital badge had still been clipped to her scrub top. When asked what happened next, Nia said she saw Angela return to her car and begin backing out carefully. She said Camille looked at the screen of her phone, tucked it down toward the console, and then moved her Porsche forward. "It wasn't a slip," Nia said. "I have watched people slide on rain. This was a choice." Martin Keene objected to the word choice, and I sustained the form of it, but I let the description stand. The witness had seen what she had seen. Samuel Louis Ortiz followed. He was 56, maintenance supervisor at the Bellhaven Medical Plaza next door, and he had finished his 2 p.m. to 10:30 p.m. shift just before the crash. He wore a clean plaid work shirt and held his cap in both hands. Samuel testified that he heard the crunch, turned, and saw Angela jerking her shoulder against the jammed door while Camille stood by the Porsche and laughed once under her breath. "Not a big laugh," he said. "The kind a person makes when they think they got away with something small." He also told Neil Benton that Camille said this is why poor people need ride shares, though he admitted on cross that he could not swear to every single word over the rain and music. Still, the line hung there because it sounded like the woman sitting at the defense table in her cream blazer. Camille rolled her eyes when he said it, and that little movement told on her more than silence would have. By 10:11 a.m., the courtroom had changed temperature. You could hear the rustle of legal pads in the gallery, the vent above the jury box, the faint clack of Eileen Foster's keyboard as she marked exhibits. Even Martin Keene had stopped giving his client reassuring little nods. He had begun listening to her the way a man listens to a ceiling beam he hopes will hold. The first motion of the day came then. Keene rose and renewed his motion to dismiss for lack of probable cause on the false report and misuse counts. He argued that his client was frightened, called first, and may have genuinely believed she was in danger. I denied the motion from the bench. I said the record already contained enough sworn testimony, dispatch timing, and physical evidence to let the matter proceed. Camille leaned back and muttered, "Not nearly low enough. This town just loves a martyr." At 10:18 a.m., I warned her for the first time. I told her she was free to confer with counsel, take notes, and defend herself with the full protection of the law, but she would not editorialize through my proceedings. She looked straight at me and said, "Noted, Your Honor," in a tone so polished it almost covered the contempt underneath. The state then called Officer Meredith Sloan, badge 233. Officer Sloan was precise, clean in her answers, and hard to shake. She testified that when she arrived at 10:56 p.m., Camille Whitmore approached before either officer had reached Angela. Sloan said Camille was animated, dry, and speaking rapidly. She claimed Angela had charged her and slammed into the Porsche while backing up. But Sloan also noticed three things right away. Angela's coffee cup was still full, unopened in the cup holder. The Civic's reverse lights were off when they first examined the car, and the damage line on the Porsche sat higher than the dent on the Civic door, which suggested forward motion from the heavier vehicle. Sloan's body camera was admitted as State's Exhibit 14. I watched it in open court with everyone else. The footage showed rain on the lens, blue emergency lights bouncing off wet asphalt, Angela speaking softly with one hand shaking, and Camille talking over her twice in under 20 seconds. Then came a small piece that mattered more than it looked. At 10:58, 11 p.m. on the recording, Officer Sloan asked, "Did anyone need medical?" Angela said, "No, my son just needs his medicine." Camille, standing 3 feet away, laughed and said, "Then maybe prioritize better." There are moments when a courtroom does not gasp because it has gone beyond gasping. This was one of those moments. The air just pulled tight. I want to tell you something that may cost me a little pride. In my first years on the bench, I sometimes mistook polish for control and tears for weakness. Have you ever had to unlearn a bad instinct you were once sure was wisdom? That case reminded me again that composure and cruelty can wear the same face until evidence pulls them apart. At 10:42 a.m., Neil Benton introduced the dispatch recording from Camille's original 911 call, certified by Bellhaven Emergency Communications. On that call, timestamped 10:48:06 p.m., Camille told the dispatcher, "A woman is threatening me in the Harper lot. She looks unstable. I think she's trying to hit my car." Her voice on the recording was calm, almost bored, like someone ordering better table service. It was a very clean lie. Then came the part that made Martin Keene take off his glasses. At 10:48:23 p.m. on the same call, the dispatcher asked whether there were injuries. Camille answered, "Not yet, but she's one of those people who gets dramatic." One of those people. She said it the way others say weather or traffic, a category, a type beneath concern. Keene objected to tone interpretation, and I sustained it, but I did not need to explain tone to the room. Every single person had heard it for themselves. Eileen marked the recording. Sergeant Haskins folded his hands behind his back. Angela sat very still with her chin tucked down, as if she wanted the sound of that voice to move past her without leaving a mark. The defense tried to answer with Camille's own testimony. That decision, I think, was made against counsel's better judgment. At 11:07 a.m., she took the stand, smoothed the front of her blazer, and looked at me like I was there to be corrected. She testified that she had been frightened by Angela's aggressive energy, that the rain had made the parking lot slick, and that any contact between the vehicles was accidental. She said she called 911 because when you're a public figure, you have to document danger. Neil Benton asked her what made her a public figure. She answered, "My family is high profile and I have a substantial online audience." He asked, "How substantial?" She said, "About 480,000 across platforms." He asked whether that audience affected her judgment that night. She smiled and said, "If anything, it makes me more careful than the average person." That was when he brought out State's Exhibit 19, a still photograph printed from body cam footage showing her Rolex at 10:57 p.m. and her phone screen lit in the other hand. He asked, "Can you explain why, while claiming fear, you continued checking your notifications?" Camille answered, "Because fear and efficiency can coexist." A low sound moved through the gallery, not laughter exactly, but the sound people make when arrogance finally stops trying to hide. By 11:26 a.m., I called a 15-minute recess. The room needed air. So did the lawyers. So did I. When I stepped into chambers, I remembered my father saying that the law can tolerate anger better than it can tolerate vanity. Angry people may still tell the truth. Vain people often fall in love with their own version of events and call it fact until the record drags them back to earth. When we resumed at 11:43 a.m., Neil Benton asked leave to introduce digital records recovered pursuant to search warrant from Camille's cloud backup. Martin Keene objected on chain of custody grounds, and I heard full argument at sidebar. The warrant had been issued on 28 April 2025 after the arraignment, after the state learned from a subpoena to Meta that certain deleted media existed but could not be viewed without device extraction. I admitted the records conditionally, subject to the testimony of the digital examiner scheduled for after lunch. Camille did not like that. She leaned toward her lawyer and whispered hard enough that my bench microphone picked up. "You said this county clown show would fold." Martin Keene closed his eyes for one full second. When he opened them, he looked older. Sometimes the next piece of a story is already walking toward the courtroom while everyone inside still thinks they understand the room. Stay with me, because after lunch, the mask did not just slip. It broke, and what was under it was uglier than even I expected. At 12:02 p.m., before lunch recess, Neil Benton called one more witness out of order because the hospital had sent a records custodian early. Her name was Paula Givens, Title Director of Health Information at St. Agnes Medical Center. She authenticated Mateo Ruiz's emergency visit records from 15th of March 2025. Those records showed a breakthrough seizure, tongue laceration, IV observation, medication administered at 1:09 a.m., and discharge at 6:54 a.m., with instructions warning that missed doses increased seizure risk. Paula was not there to speculate on medicine. She was there to certify records. Even so, the paper spoke clearly enough. Exhibit 23 showed the timing. Exhibit 24 showed the discharge summary. Exhibit 25 showed Angela's work absence report for 2 scheduled pediatric shifts on 15 and 16th of March. The defense could argue intent on the roadway. It could not argue those hours back into existence. At 12:18 p.m., Martin Keene renewed a request for continuance, saying the digital examiner was central and his client needed time to consider stipulations. I denied a broad continuance and granted only the lunch recess already scheduled, with testimony to resume at 1:30 p.m. Camille made a small, disgusted sound and reached for her Louis Vuitton phone case. Sergeant Haskins took one step forward without being asked. She set the phone back down. During lunch, I stayed in chambers with half a sandwich I never finished. Eileen brought me the probation summary and the pretrial notes. That was when I saw one detail I had not yet spoken aloud. On 31st March 2025, during the bond hearing, Camille had requested release without travel limits because she had brand commitments in Miami and Milan. Not work obligations, not school, not caregiving, brand commitments. My father would have said that modern vanity has learned to invoice itself. We resumed at 1:31 p.m. The courtroom was fuller than before. Word travels fast through a courthouse. A second reporter had arrived. So had 2 law students from Belhaven State who sat in the back row with notebooks on their knees and expressions that said they had expected parking tickets and had instead found a lesson. Cho explained things simply, which I appreciated. She told the room a deleted post is often not gone. It may remain in a cloud backup, in a cache, in draft memory, or in server copies returned through warrant. Then she looked at the monitor, asked permission to publish State's Exhibit 31, and the whole emotional shape of that day changed. The screen showed an Instagram story posted from Camille's account, Cam Whitmore Official, at 11:08 p.m. on 14th of March 2025, then deleted at 11:19 p.m. The frame was shot from inside the Porsche. You could see Angela's dented Civic in the rain, her scrub top, her hospital badge, and the white pharmacy bag in her hand. Over the image were the words, in pale pink text, "When the help gets brave." Under that, a laughing emoji. There are no good sounds after a line like that. No cough fits, no whispers, just the whole room taking one stunned breath and then refusing to spend it. Angela closed her eyes, not dramatically, just once, like someone bracing against cold water. Martin Keene did not look at his client. He stared at the table because lawyers know when a case has crossed a line, evidence can no longer uncross. Lieutenant Cho was not finished. State's Exhibit 32 was a TikTok draft saved at 11:12 p.m. that same night, never posted but preserved in app storage. It showed Camille adjusting her hair in the mirror of the Porsche with the caption, "Broke people weaponize tears." Cho testified the metadata placed the draft within 12 feet of Harper Family Pharmacy and within 4 minutes of the 911 call. Then came Exhibit 33, a text message to one Lila V at 11:14 p.m. Tapped her junker, called 911 first. That's how you win. If you know someone who has ever been told their pain mattered less because they had less money, less status, or a quieter voice, send this story to them when it is over, not because it will erase what happened to them, because sometimes hearing that the record finally caught up to somebody can keep a person from giving up on fairness altogether. At 1:52 p.m., Neil Benton played the Instagram audio again, slower. She said her son needed meds, not my emergency. The sentence sat in the room like broken glass. This was no longer about a dented door and a bad attitude in a wet parking lot. This was about choice, contempt, and a woman who heard a child's medical need and treated it as a punchline. Martin Keene asked to voir dire the witness outside the merits, but there was little left to test. The account was hers. The device was hers. The timestamp matched. The voice was hers. The captions were hers. Even the location matched the dispatch CAD and body cam clock after a standard 2-second synchronization adjustment. Lieutenant Cho gave each answer without heat. That made it worse. Then Neil Benton asked for Exhibit 34. I can still hear the plastic click as Eileen handed it up. It was a zoomed forensic still from the Instagram story, enhanced but not altered. Reflected in the wet black paint of the Porsche door just over Camille's left shoulder was the angle of her front wheel turned toward Angela's driver door before contact. Lieutenant Cho explained that the reflection matched the damage trajectory analysis from the collision report. In plain words, the video she made to mock Angela also caught the setup of the strike. Martin Keene stood then and requested a recess to confer with his client. I granted 10 minutes. Camille did not move for several seconds. For the first time that day, her face lost its confident arrangement. Not remorse, something colder. The look of a person realizing the mirror had betrayed her. When the parties returned, Keene informed me his client would withdraw any further claim that the collision was pure accident. He then tried to reframe the matter as immature conduct inflated by public scrutiny. Neil Benton objected before I even had to, and I told counsel I would decide the case on the evidence, not on a softer adjective. Immature people spill wine. They do not usually drive metal into metal and laugh about a child missing medicine. The next witness was Dr. Helen Banerjee, Chief of Pediatric Neurology at St. Agnes Medical Center. She had come directly from clinic and still wore her white coat over blue slacks. The room changed again when she took the oath. Authority walks differently when it carries no need to impress anyone. Dr. Banerjee testified she reviewed Mateo Ruiz's chart, medication history, and seizure management plan. In her medical opinion, stated to a reasonable degree of medical certainty, the missed evening dose on 14th of March materially increased the likelihood of the breakthrough seizure that occurred just after midnight. She was careful with her language. She did not say one thing caused all things. She said the delay mattered a lot. Neil Benton asked whether prompt access to the refill would have reduced the risk. She said, yes. He asked whether a caregiver hearing, "My son needs meds tonight," would understand that urgency in ordinary language. Dr. Banerjee said, yes. He asked whether the harm here went beyond vehicle damage. She looked toward Angela once and answered, yes, a child experienced avoidable medical destabilization. That was the moment the room stopped seeing Angela Ruiz as a woman with a dented Honda and started seeing exactly what had been taken from her family that night: safety, time, sleep, trust. The right to handle a child's illness without someone richer deciding that need was amusing. If this part is stirring something in you, I want you to sit with that feeling and ask yourself a hard question. When have you been the one trying to explain a real need to somebody who had already decided you were beneath urgency? I ask, because this courtroom was full of more than one kind of witness that day. By 2:11 p.m., Camille Whitmore was no longer performing calm. She was tapping one heel under counsel table. She interrupted twice. She called Dr. Banerjee's testimony speculative medical theater before I cut her off and reminded her that further outbursts would trigger a contempt finding. Her jaw clenched. The skin along her neck had begun to flush. Neil Benton then moved to admit one more document, State's Exhibit 39, a records packet from St. Agnes Human Resources. Martin Keene objected on relevance, but the state argued the packet showed foreseeable harm flowing from the false report and online post. I reviewed it, heard argument, and admitted limited portions. Those pages showed that on Monday, 17th of March, 2025, after Camille's deleted story had been screen recorded and circulated locally, St. Agnes placed Angela on temporary non-patient status for 13 days pending review because online complaints had falsely identified her as violent toward the public. She lost 2,184 exams in shift differentials and overtime during that review. Angela had not volunteered that number earlier. That told me something too. People playing for pity usually lead with every bruise. People surviving often mention the worst part last because they are used to carrying it without help. Then came the witness who preserved the deleted story before it vanished. Her name was Kelsey Rowan, 32, owner of Rowan Beauty Loft on River Avenue. She said she followed Camille's account because a salon client had once talked about a sponsored giveaway. At 11:09 p.m. on 14th of March, she screen recorded the Instagram story because the caption, "When the help gets brave," disgusted her. She saved it because Angela's hospital badge was visible and because Camille laughed after saying a child's medicine was not her emergency. Kelsey's recording matched Lieutenant Cho's recovery exactly. On cross, Keene asked whether Kelsey disliked wealthy influencers. Kelsey answered, "No, sir, I dislike bullies with ring lights." The gallery almost broke then. I had to rap the bench once and say very calmly, "This is still a courtroom, but I will tell you the truth." Even I felt that line hit home. At 2:18 p.m., Martin Keene made his final stand on tone rather than facts. He argued his client had grown up in a public family, had poor judgment, had been reckless with words, but should not have her life crushed over one petty municipal event. That phrase did not help him. Petty municipal event. A dented car, a false police report, a child's seizure, lost wages, viral humiliation. All reduced to a phrase small enough to fit inside privilege. I was about to ask whether the defense wished to rest when Camille did something I have only seen twice in 28 years, and never with such arrogance behind it. She stood up before her lawyer could stop her, snatched her phone from the table and said, "No, I am not letting some small-town robe trap me in this circus." Then she looked directly at me and added, "You are a glorified traffic judge. You think this is Judge Judy with better wallpaper." The room made a sound like a single body flinching. I told her to sit down. She did not. I told her again, and this time I added that she was on the edge of direct contempt. She held up one manicured finger as if I were the one interrupting her and pressed 911 on speaker. You could hear the ring through the courtroom microphones. It sounded obscene in that room. When the dispatcher answered, Camille said, "Yes, I'm at Belhaven Municipal Court, Courtroom 2. This judge is unlawfully detaining me and refusing to let me leave. I need county officers here now." Sergeant Haskins took one step, then stopped because I raised my hand. I wanted the record. I wanted every word. 30 seconds can be a very long time when somebody finally runs out of room to hide. Listen closely to what came next because it was the instant the whole performance collapsed under its own weight. The dispatcher's voice came back sharp and clear over speaker. "Ma'am, this is an active court proceeding with uniformed officers present. You are not being kidnapped. Misuse of 911 is a criminal offense, and this call is being recorded." Camille's face changed before the dispatcher had even finished the word recorded. And then, as if the day itself had decided timing mattered, the side door opened and Chief Elise Warren stepped in. Chief Warren was director of Belhaven Emergency Communications, former patrol lieutenant, no patience in her posture at all. She had been subpoenaed for the original dispatch certification and had arrived from a county budget meeting 3 minutes late. In her hand was a sealed packet and a printed CAD log. She took one look at Camille standing with the phone, one look at me, and said, "Your Honor, dispatch has now logged a second false emergency call from Ms. Whitmore at 2:19 p.m. I can certify both calls and response status. I have rarely seen regret arrive so fast on a human face." Camille lowered the phone, but not before the dispatcher added, "Units already on site, ma'am. Terminate misuse of the line." Every reporter's pen moved at once. Martin Keene whispered, "Camille, give me the phone." and for the first time all day she obeyed someone immediately. Chief Warren took the stand after the oath and authenticated both 911 calls. She also brought the KD event notes from 14th of March. Those notes showed something Officer Pike had not included in his initial summary. At 11:05 p.m., while still on scene, Camille had told dispatch, "Make sure the officers know who my father is." The note was entered verbatim by dispatcher Talia Reed, employee ID EC771. Chief Warren confirmed it under oath. Then she produced one more document I had not known she possessed. It was a supervisory audit memo dated 20th of March, 2025. After a citizen complaint by Samuel Ortiz, dispatch had reviewed the audio and discovered that Officer Pike's first written supplement omitted Camille's statement about her father and omitted Angela's repeated reference to her son's medicine. Internal review had already corrected the file on 26th of March. Pike's omission was now under professional standards investigation. That was the hidden, deeper truth. The case had not simply been about a rich woman hitting a tired nurse and lying first. It was about how quickly systems can bend when status enters the room, how one false report can tilt police attention, hospital scrutiny, and public blame toward the wrong person before the facts have had time to stand up. Chief Warren said it more cleanly than most lawyers could have. "The first caller gets the first presumption," she testified. "When that caller also invokes political influence, the risk of bad triage goes up. That is why truthful emergency reporting matters." You could almost hear my father agreeing from whatever quiet place the dead keep their principles. At 2:33 p.m., I found Camille Whitmore in direct contempt of court for the in-court 911 misuse and for repeated defiance of lawful orders. I imposed summary sanctions of 48 hours, suspended pending final sentencing, and directed Sergeant Haskins to secure her phone as an evidentiary item. She started to say something, then stopped. The sound that replaced her voice was the low mechanical hum of the vent above the flags. "If you believe real justice is still possible in this world, even in small rooms with old benches and tired clerks, I want you to stay with me through the last part, because justice is not only about catching a lie, it is about deciding what the truth now requires from everyone who heard it." Closing arguments began at 2:41 p.m. Neil Benton was measured, which was smart. He did not need fireworks. He walked through the counts one by one, criminal damaging, shown by witness testimony, damage pattern, and reflected wheel angle. False report shown by the original 911 call, body cam contradiction, and Camille's own post. Misuse of emergency services shown twice now, once in the lot and once in my courtroom. Reckless operation shown by intentional vehicle movement in a wet lot crowded with pedestrians. Then he spoke about harm. He listed the repair bill, the rental cost, the ambulance charge, the lost wages from missed shifts, the additional lost wages from the hospital review triggered by the viral post, and the plain human damage that does not invoice well. He asked for jail time, restitution, probation, driving restrictions, and a sentence with enough moral geometry that the defendant has to walk the distance she forced others to walk. Martin Keene stood with the look of a man trying to salvage dignity rather than victory. He admitted the social posts were cruel and that the in-court call had been indefensible. He asked me to consider Camille's age, lack of prior criminal record, and the danger of making one person carry the burden of our anger at class and influence. That was a fair argument as far as it went. Sentencing cannot become theater for public resentment. I listened closely because fairness requires that too. Then I offered allocution. Angela Ruiz stood first. She held Mateo's folded school note in one hand, though she never opened it. She said, "Your Honor, I am not asking for revenge. I just want the record to stop calling me what I am not. I want my son to know that if someone with money lies about you, it is still possible for the truth to catch up." Then she sat down. Camille Whitmore stood next. Her blazer was gone by then, draped over the chair. Under the silk shell, her shoulders looked smaller but not softer. She did not apologize to Angela. She said, "This has been blown into a morality play because my last name is useful. I made mistakes. I did not deserve this level of public humiliation. Public humiliation, not the child, not the lie, not the woman she called the help, herself." I asked her directly, "Ms. Whitmore, do you understand now that when you heard a mother tell you her son needed medicine, you held a piece of another family's safety in your hand?" She stared at me, jaw working once. I understand people are exaggerating consequences to punish me, she said. That answer told me everything I needed to know about remorse. The courtroom had grown so still I could hear Eileen Foster turning one page in the file. One page, thin paper, soft scrape. That was all. There are moments when I wish I could lend people the voice of my father for just 10 seconds. He would have said what I was already thinking. Power is not proven by how far you can push someone weaker. Power is proven by what you refuse to do when you know you could get away with it. I took 7 full minutes before I spoke. Some judges fill silence because it scares them. I have learned to trust it. Silence lets truth finish arriving. I looked at Angela, at Martin Keene, at Camille, at Chief Warren, at Dr. Banerjee still seated in the second row, at Sergeant Haskins by the rail, at Eileen with her hands folded over the docket. Then I began. I said, "This court does not sentence people for being rich, famous, disliked, online, rude, or politically connected. It sentences for conduct proved beyond the standard the law requires. It also does not confuse Polish with character. A defendant may wear Tom Ford and speak in measured tones and still act with meanness so deliberate that the record can feel it." I said on 14th of March 2025, when Angela Ruiz told you she needed to get medicine to her son, you did not face an emergency. You faced a choice. You could have moved your car 3 feet and let a tired nurse go home. Instead, you moved your car the wrong way, created damage, called 911 first to seize the first presumption, and then mocked the very harm you had caused. In this courtroom today, when the truth closed in, you misused that same emergency line again because you believed public systems existed to rescue you from accountability. Nobody moved. Even the reporters had stopped writing for a moment. I continued. My father taught me long before I ever wore this robe that rules without heart become weapons. He also taught me that the courtroom is the last place on earth where every person stands equal or the room loses its purpose. Ms. Whitmore, you came in here believing equality was an insult. You treated an emergency line like a concierge service. You treated a nurse like staff. You treated a child's medication as content. That is not immaturity. That is moral failure expressed through choices. At 3:07 p.m., I pronounced sentence. On count 1, criminal damaging, 180 days in the Belhaven County Jail with 150 days suspended. On count 2, false report, 180 days with 120 suspended consecutive to count 1 to the extent of 15 actual days. On count 3, misuse of emergency services, 90 days suspended. On count 4, reckless operation, 30 days suspended and a 1-year license suspension with occupational driving privileges only for court, probation, and verified medical appointments. That gave her 45 actual days to serve, not all at once in a blaze of spectacle, but as a real consequence that could neither be posted away nor laughed off. I then imposed 24 months of supervised probation. Then I turned to restitution because justice without repair is only half awake. I ordered restitution to Angela Ruiz in the exact amount of $7,825 broken down as follows: $4,886.73 for vehicle repair, $418.97 for rental transportation, $936.40 for ambulance charges, $284 for lost shift differential and overtime during the hospital review, and no duplication for the 2 missed standard shifts because those had already been absorbed through paid leave. I also ordered $250 to Belhaven Emergency Communications for response and administrative cost tied to the 2 false emergency calls. Then I added the part that made the room lean forward. As a condition of probation, Camille Whitmore would complete 400 hours of community service with Belhaven Night Access Transit, a municipal nonprofit partner that transports residents to after-hours pharmacies, dialysis appointments, and emergency pediatric refills. She would work those hours in plain county-issued service clothing, not for public humiliation, but because the work itself mirrored the harm. For 1 year, she would spend Friday nights and weekend overnights helping people get the medicine and transport she once treated as optional. That condition was lawful, tailored, and in my view, necessary. It did not ask her to suffer randomly. It required her to stand face to face with the kind of urgency she had mocked. It required time to do its slow work on her. I also prohibited her from posting, monetizing, or otherwise distributing any image, recording, or commentary identifying Angela Ruiz or her family during probation. Violation would trigger revocation proceedings. I ordered completion of a digital conduct course, a victim empathy program, and a formal written acknowledgement of the falsity of her March 14th statements to be filed with the court and provided to St. Agnes Human Resources so the record could stop bending against the wrong woman. Martin Keene asked whether I would consider work release or conversion of the jail term to home detention. I said no. I said this defendant had already demonstrated that supervision from a comfortable distance did not meaningfully restrain her. Some consequences must require the body to feel time passing. Camille finally reacted then in a way no designer fabric could soften. Her face went white first, then red in sharp patches. Her mouth opened, closed, opened again. 45 days, she said, and the words came out small, almost childlike. For this, I answered, for this pattern of conduct, yes. She looked toward the gallery as if somebody there might still be able to explain that the world had made a procedural mistake. No one moved to save her. Sergeant Haskins stepped closer, not touching her, just near enough that reality had a shape. Eileen read the payment schedule and reporting conditions into the record. The law students in the back were writing so fast, their wrists would ache later. Angela Ruiz sat with her hands folded around that manila folder, breathing in through the nose, out through the mouth, like a nurse talking herself through pain. If something inside you has been waiting all story for the law to speak plainly, press that feeling down into your memory right now. Not because a sentence solves everything, because sometimes a fair consequence, spoken without spite, is the closest thing a wounded room gets to clean air. I was not finished. I looked at Camille and said, Ms. Whitmore, a court cannot give Angela Ruiz back the night you took from her family. It cannot erase her son's fear or her mother's panic or the days her own hospital questioned her because you were louder first. But it can say, without flinching, that money does not convert cruelty into misunderstanding. Not here. Then I looked at Angela. Ms. Ruiz, this court finds that your account was credible, your restraint was real, and the official record shall reflect that you were the victim of intentional conduct, false reporting, and subsequent online humiliation. You do not leave this courtroom under suspicion. I have seen relief arrive in many forms. On Angela Ruiz, it arrived as a smaller thing. Her shoulders dropped less than an inch. Her eyes filled, but no tears fell. She just nodded once like a woman who had been holding up a wall alone and had finally been told she could set one corner of it down. Camille's attorney requested a stay of sentence pending appeal bond. I granted a limited 24-hour self-surrender window only because the law allowed it and because he agreed to immediate passport hold and electronic monitoring placement by 6 p.m. that evening. Camille whispered, Dad will fix this. I answered, he may hire counsel. He may not edit the record. That line traveled farther than my bench usually does. When court adjourned at 3:24 p.m., the room still did not break right away. People stayed seated a second longer than normal. That is how I know a courtroom has become more than a room. It begins holding the silence for people because they cannot yet hold it themselves. Chief Warren gathered her packet. Dr. Banerjee buttoned her coat. Neil Benton stacked exhibits with the tired care of a man who knew he had carried a hard case to the line. Martin Keene put one hand on Camille's chair and said something too low for me to hear. Whatever it was, she did not answer. Then came the small moment that mattered most to me. Angela waited until almost everyone had gone. She approached the rail with that same folder held against her chest. Sergeant Haskins glanced at me, and I nodded. She said, Your Honor, my son wanted me to tell you something. She unfolded a page of notebook paper. Mateo had written in careful block letters, Thank you for believing my mom, even though she is not important on the internet. I had to look down at my hands for 1 second before I trusted my own voice. Then I said, Please tell your son he is wrong about one part. His mother is very important. Angela gave a tired little smile and answered, I know, but it helped him to hear the court say it too. She turned to go, then looked back and said, My father used to say people tell you who they are in the first minute. I think your father and mine would have gotten along. I smiled at that, more than I usually let myself in open court. I think they would have argued first, I said. She laughed softly. Then she left. There are stories that end with a gavel and stories that only begin there. If you need a minute, take it. But do not drift away now, because what happened after that sentence taught me just as much as the trial itself. 43 days later, on Friday, 1st August 2025, I was in chambers finishing a bond docket when Eileen Foster brought me a plain white envelope with no return logo. Inside was a typed report from Belhaven Probation. Camille Whitmore had completed 12 of her 400 service hours at Belhaven Night Access Transit and had filed 3 separate complaints in the first 2 weekends about odor, client hostility, and unsuitable tasks. The probation officer's note at the bottom read, "Subject appeared profoundly unprepared for proximity to ordinary need." It should not have made me smile, but it did just a little. Not because discomfort is justice by itself, because some people have lived so long inside insulation that truth has to reach them through very practical doors. A cold curb at 1:10 a.m., a dialysis rider waiting in house shoes, a grandmother counting pills under a porch light. Those things can teach what lectures cannot. By the end of September, the tone of the reports changed. No miracle, no sudden sainthood, just change. On 19th of September 2025, probation noted that Camille stayed 47 minutes past her assigned shift to help reroute a transport after a missed handoff to a mother needing amoxicillin for a feverish child. On 3rd October, she asked the site supervisor why so many people waited until night for refills and was told, because jobs do not always let people leave when medicine is open. The report said she had no response. In November, Belhaven Community Foundation announced a small grant, $18,000, to expand Night Access Transit's weekend pharmacy run capacity. The money did not come from Camille. It came from local donors after the case drew attention to how many working families in Belhaven were one delayed prescription away from disaster. Sometimes justice ripples because it shames a system into seeing what it had stepped around. Angela Ruiz returned fully to pediatric duty on 31st March 2025 after the hospital cleared her, but the court order in June helped something deeper. St. Agnes Human Resources sent an amended internal memo removing all adverse references linked to the false online allegations. In August, she was offered the charge nurse training slot she had been passed over for during the review cloud. She took it, though she later told probation she almost said no because she was tired of being visible. I understood that. Mateo Ruiz did not become a symbol. Thank God for that. He became what children are supposed to become when adults finally stop failing them for 5 quiet minutes in a row. He went back to school. He wrote a science fair project on how emergency medications work in the brain. In January 2026, he won 2nd place at the district competition with a trifold board so neat it looked ironed.